The council tax lie, how liability orders became an illegal threat. I remember the day it began like any other. I was making a cup of tea in my small kitchen, half distracted, half awake. The post dropped through the door, and I shuffled over in my slippers to collect it, thinking it would be another leaflet or broadband offer. But nestled in the pile was a brown windowed envelope stamped with the local council's logo. Thick paper. Serious font. I nearly dropped my mug. My skin tingled with dread as I tore it open. My eyes raced through the bold type. You have been served with notice. I read it again, slower this time. I was being accused of not paying my council tax. It made no sense. I always paid. Direct debit, on time, without fail. A week later, another letter arrived. Then another, each more urgent, more threatening. The tone shifted from polite reminder to full legal pressure. And then, as if someone had skipped a chapter, a court summons showed up in my post. No one called. No one knocked to ask for clarification. No questions. Just decisions made behind closed doors. Then came the final blow, a liability order. The letter said enforcement had begun. I was now in official default and bailiffs were on their way. A month later, they came. Heavy knock, black boots, clipboard, demands. I stood there, heart racing, trying to explain. I had proof bank statements, transaction records, emails confirming payment, but none of it mattered. They didn't care. Because what I didn't know was that council tax enforcement, at least the way it's done, was often unlawful. It skips real courtrooms. It ignores constitutional rights. It pretends that a spreadsheet rubber-stamped by a clerk is the same as a court judgment. It isn't. And what's worse, the system depends on people like me not knowing any better. That was the day I realized this wasn't just about unpaid tax. It was about a silent dismantling of due process, one envelope at a time. And I wasn't the only one caught in it. Let's pause and reset. This isn't just about confusing paperwork or wading through dense legal language. It's about something far more serious: your rights. Your constitutional rights, which still apply today, right here in England. These aren't just dusty clauses in an old law book. They are living, binding legal principles that have stood for centuries. Rights that were established as early as 1215 with the original Magna Carta and reaffirmed through the Petition of Right, 1628, the Bill of Rights, 1688, and many acts that followed. The key principle they protect? Due process of law. Put simply, no one can be punished, fined, have their property taken, or their freedom limited without a fair legal process. That means an impartial hearing. That means real evidence. That means a courtroom, not a council spreadsheet. As the Magna Carta clearly states, no free man shall be seized, imprisoned, stripped of his rights or possessions, except by the lawful judgment of his equals or by the law of the land. That's not poetic fluff. That's the bedrock of English constitutional law. So when councils send out liability orders without hearings, without judicial review, without even your presence, they're not just being aggressive. They're bypassing the Constitution. And here's the most alarming part. They do it regularly, quietly, bureaucratically. Most people don't even realize it's happening because we're taught to accept these things as official. But legality is not determined by logos and letterheads. It's determined by whether the law has been properly followed. And when due process is skipped, the entire enforcement is void, plain and simple. Now, here's where the system breaks down, and it's not a small crack. It's a structural failure. Under the Local Government Finance Act, 1992, and its supporting council tax, administration and enforcement, regulations, local councils are granted authority to apply for something called a liability order, a legal document that supposedly confirms a person owes unpaid council tax. Sounds official, right? Sounds fair? But here's how it really happens. Councils don't present individual cases. They don't bring witnesses, evidence, or even the person being accused into the courtroom. What they bring is a spreadsheet. A list of names, sometimes hundreds, even thousands, matched to amounts supposedly owed. That list is handed to the magistrate's court, and instead of a hearing with scrutiny, the list is rubber-stamped by a court officer or clerk. No judge looks at the case. No one hears your side. No one checks whether the debt is correct or even exists. It's an administrative production line. But here's the critical point. There is no actual judicial process involved. In the landmark case Leighton v. Bristow and Sutor, the council was asked to produce the court's sealed liability order. They couldn't. Why? Because it didn't exist. What they presented was a printout, an internal list, not a judgment signed and sealed by a magistrate. That's not due process. That's bureaucracy pretending to be justice. And yet, bailiffs and enforcement agents act as if it's a full court order. This is in direct violation of Regulation 35, 3 of the Council Tax Regulations 1992, which plainly states, "A liability order shall not be treated as a sum adjudged to be paid by order of the court." Let that sink in. It's not a court judgment. There's no lawful power behind it. No signature from a judge. No court minutes. No transcript. Just a document generated in a back-office process without scrutiny. Still, councils use these paper tigers to unleash real enforcement. Visits, threats, asset seizure. That's not just misleading, it's unlawful. And the worst part? Most people never even know it. Imagine standing in a courtroom. Bright lights, polished wood benches, a magistrate peering over their glasses. You're called forward. You state your case. Evidence is reviewed. You're asked to respond. Then and only then a legal judgment is handed down. That's how we imagine justice works. Now, forget all that. Because when it comes to council tax liability orders, none of that happens. There is no courtroom, no judge, no hearing, no defense. What actually happens is this. The local council prepares a spreadsheet, a basic Excel sheet with hundreds, sometimes thousands of names and amounts allegedly owed. That list is sent to the magistrate's court. But there's no scrutiny, no case-by-case analysis. A court clerk, often a junior civil servant, glances over it and signs off administratively. That spreadsheet becomes the basis for what they call a liability order. It looks official. It feels intimidating. But here's the truth. There's no judgment behind it. It's a list, not a verdict. Despite this, councils treat it as though it's been properly adjudicated in court. Bailiffs are dispatched. Threats are issued. Property is seized. But enforcement based on an order that's never been lawfully made? That's not just shady, it's unconstitutional. Because actions like bankruptcy, petitions, or charging orders, which carry devastating consequences, are only allowed after a lawful judgment by a court. Without that judgment, those actions collapse under legal scrutiny. So when councils pursue enforcement without a hearing, without evidence, and without judicial oversight, what they're really doing is pretending. Pretending their spreadsheet is a judge. Pretending due process happened. Pretending you don't have rights. But rights don't disappear just because paperwork says so. And real justice can't be replaced by automation. Liability orders are like a domino setup, carefully arranged to knock you down, piece by piece. It starts with a spreadsheet, not a judgment. That spreadsheet becomes a liability order issued not through a proper court process, but via a mass administrative rubber stamp. No judge, no courtroom, no due process. But it doesn't end there. That so-called liability order becomes the foundation for more serious, damaging legal actions. Under Regulation 49 of the Council Tax, Administration and Enforcement, Regulations 1992, councils can apply for bankruptcy petitions if you owe 5, 0, or more. Under Regulation 50, they can issue charging orders, which place a legal claim on your property, your home, until the debt is cleared. Sounds serious? That's because it is. But both of these powerful tools rely on one key legal assumption, that a lawful court debt exists. And here's the problem: it doesn't. There was no judicial hearing, no opportunity to contest the amount, no signature from a magistrate, no sealed judgment. What's been called a liability order is actually just an internal lister, glorified invoice masquerading as a court judgment. Even Regulation 35(3) confirms this. It states clearly that a liability order is not to be treated as a sum adjudged to be paid by order of the court. That phrase alone legally separates it from a real court ruling. So when councils escalate enforcement, sending bailiffs, freezing accounts, pursuing bankruptcy, they are acting ultra vires. That means beyond their lawful power. In short, the entire enforcement process built on a foundation of fake judicial authority is unlawful. But unless you know your rights, they count on you believing it's legitimate. And that's the real trap. This isn't about clever tax dodging. It's about reminding the state or a council of a vital fact. Due process is mandatory, not optional. You can't bypass courts, you can't rubber stamp threats, and you can't treat spreadsheets like judicial orders. Yet councils do because nobody scrutinizes them. It's easier to send bailiffs, but it's not lawful. And once we see it, we can stand in truth. Now, you understand those final notices backed by liability orders? They're unconstitutional unless processed lawfully in open court. That envelope in your hand is not just a bill, it's a threat built on missing legal bricks. It doesn't matter if you owe the money. You still deserve your voice in court. You still deserve a judge's ruling, not a clerk's approval. Spread the word. This isn't about scamming or dodging fees, it's about your rights, the rule of law, the Constitution, the protections granted to you. If this made your jaw drop or just got your wheels turning, share it. Let the councils remember who owns the law. You don't need to shout. Just stand in the truth. Takeaway summary: council tax enforcement often avoids real due process. Liability orders can be rubber-stamped without hearings, illegal under Constitution. Bankruptcy and charging orders based on those are also void. You have a right to judicial proceedings, nothing less. Stay calm. Know your rights. Call to action. If this information helped you, support it. Share it with someone facing council threats or with a community leader, because the law belongs to the PO. Plan up bureaucratic sneaks in spreadsheets.